Next up.
Thank you very much.
Thank you. Stephen. Please state your name for the record. You have 3 minutes.
Thank you. Mr. Chair and Committee, my name is Stephen Charbonneau, and I'm here on behalf of the Arizona Attorneys for Criminal Justice to speak in opposition of the bill. A couple of the underlying problems that we have with the bill is that it basically is creating a reporting industry on an issue that hasn't been shown that's really a problem on the small population. And it's creating this industry at the peril of the Department of Transportation. It's what it's doing is it's taking a problem that is not a problem, creating a ton of work for an administrative agency, and then creating an industry to solve that problem. So it's really creating, from what I can see, is a governmental dependency on a private industry, and it's not really solving any issue by doing that. One of the other problems that we have is with enforcement. Currently, law enforcement is responsible for enforcing violations of the license restrictions. What this is doing, by the very definition of case management service provider, is that it's saying that this case management service provider would be reporting the violations, presumably to ADOT, and there's a lot of missing pieces of how this would actually work. But what that means is that now this case management service provider would be the ones that are deciding when violations are occurring. And this is problematic because, as was discussed earlier, for individuals that have jobs like food truck drivers or contractors, the previous speaker kind of went over some of that, but it wasn't clear how that would be enforced. I mean, if the position is that, well, we're just going to open it up from 9 to 5 during the weekdays, then I'm not sure I see the point of implementing this large program. And with that, I'll stand for questions.
Yeah, I would just say there's no real burden on ADOT or anybody, because this is all being handled by the contractor who does the interlock, and they would be sending notices of violation to ADOT for them to take whatever enforcement action is necessary. And nobody's really deciding who is in violation. What they're doing is they're looking at hard data which shows that this vehicle with this person's picture is at this location and it's nowhere near where they were supposed to be. So it's not like it's a subjective, oh, I'll nail them, I won't nail them. They're simply transmitting hard data that basically proves that that person was there with a picture and a geofence. So I don't think there's subjective discretion, and there's there's no monumental burden on ADOT. And you might also want to address the fact that a whole lot of people will voluntarily be able to put themselves into this system and avoid being without a vehicle and perhaps out of work for the first 30 days.
If I may respond
Yeah.
to that, Chairman?
Yes.
So to the first point, the bill mandates that that global positioning system locations, the device, are supposed to be reported each time the vehicle's ignition is successfully started and disengaged. Nowhere in the bill does it say who it reports to.
It goes to the interlock operator. They're the ones who analyze the data.
Right. So
Which is what this happens now, by the way. This data is already being transmitted, but it's not being used for the purposes of geofencing. It's just being used for the purposes of, who's blowing into the device.
Sure. So I guess my point would be that by doing this and reporting this it would, in my opinion, place burdens upon ADOT. I know ADOT's here, and maybe they'll come up and speak to that. I'm not sure. So I'll leave that to them to decide whether that'll place burdens on them.
Let me ask you one question, though. The second point, don't you think it's a good thing to allow people who ordinarily would get a hard 30-day suspension to opt into an interlock in this monitoring early, and also begin their mandatory interlock period early?
Absolutely, and I don't think that we're opposed to that portion of the bill. I think that the main concerns are with enforcement. So as I said earlier, in the case management service provider definition, it does say that they're responsible for reporting the violations. So what that means to me, how I read that, is that they would be responsible for looking where they're supposed to be during certain amount of times and deciding whether that person has violated Section 28-144.
Representative Germain.
Thank you, Chairman Kavanaugh. And I apologize for being a little bit late this morning. My daughter's school starts at 8 a.m. But with the proposed geofencing, how do they tell who is actually driving the vehicle? It could be a spouse or a child that does not have.
To that point, when the geo thing is taken, a picture of the driver is also taken, and that's how they match it. All right, thank you.
Well, I had a couple of questions.
Okay, go ahead.
Thank you, Mr. Chairman. Sir, so one of the questions I had is, I just want to clarify, in your testimony, it sounds like you're saying that the issues that you have with this bill they tie into the administrative oversight and how the program is actually carried out in the real world. Is that fair to say?
Yes, Representative.
And Mr. Chairman, just one other question. I'll throw this out to you, sir, if you know, and to others as they come up. But the vendors who would be overseeing any violations and having the data come through their office, who owns that data?
I don't know if it's owned. It's data that is required to be collected by law. The Interlock company is essentially an approved vendor who collects this data and transmits it to ADOT. So I don't know if anybody actually owns it where they can, say you can't look at it. It becomes an enforcement record, much like if probation requires somebody to go to a doctor's office for treatment, they might require the doctor to send proof of the appointment. I mean, it's just information.
And Mr. Chairman, then would you be open to an amendment or a few lines that clarify that the information that goes through the vendors cannot be sold to a third party, will not be distributed to a third party?
Oh, yeah, sure, absolutely. Yeah, if you want to, you can just prepare that amendment. It'll be a friendly one.
I've got one right here.
Okay. Draw.
I'll draw it right here. Sure, thank you.
Okay.
Working at the speed of business.
Anybody
I love
else?
it.
Okay, and just one quick thing. Understand, the information that is being given is not a burden to, it shouldn't be a burden to ADOT. It should be welcomed information which allows them to perform their duty to ensure that people are complying with the terms of their interlock and CERTL. This is kind of like, if a police officer calls a probation officer and says, hey, I just arrested somebody who I see, and his business card is in your pocket. He may, in fact, be one of your probation people, and I want you to know I just locked him up for shoplifting. That information to probation officer isn't burdensome information that overwhelms them. That's information with that probation officer needs to know to properly enforce the terms of the law.
And if I may clarify, Mr.
Yeah.
Chairman, maybe the burden was a poor choice of words on my part. And if I understand what you're saying, is what you're saying is that what they're doing is they're helping enforcement, and so that shouldn't be a problem. That should be welcome because they're helping enforcement. I guess my point to that is that they're helping enforce something that is not a big issue, and by doing that, they're placing more work on an already congested workload with the Arizona Department of Transportation.
It's okay.
Thank you.
All right. Yes, President Blanc.
Thank you so much, Mr. Chairman. Is a representative from ADOT here who can speak on the concerns noted?